Okay.
Calling case 2024-2849 DC, Mary Aldering versus Stephen Smith. Today is Monday, December 2nd, 2024 at 9:24 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff. This matter is before the court on the plaintiff's motion regarding parenting time and supervision. The court notes that this matter was originally set last week on November 25th, 2024, and adjourned 1 week at the request of the defendant. Again, the matter before the court is a motion regarding parenting time supervision. Ms. Podolsky, you can proceed.
Thank you, Your Honor. We were actually initially back in court several weeks ago. The court made a ruling regarding custody, parenting time, support, and supervision. In that ruling, the court ordered that defendant's mother would provide supervision for defendant's parenting time. That was something she was initially willing to do. However, as we've stated in our motion, that is not something that she is comfortable doing any longer. As she's outlined in the motion, or we've outlined, and she has attested to in her affidavit, the defendant has told her no less than 2 times that if he is there with her and the minor child, he is going to take the minor child. She believes him when he makes these statements. He's been very reassuring to her that this is something that will happen. His behavior has been erratic and volatile, and she's afraid that she simply would not be able to stop that situation if that were to happen. So we're asking the court to amend the order as it relates to supervision, that the supervision occur at Family and Children's Services at an expense of the defendant. We do believe that this is in the minor child's best interest. As we had previously stated, this just defendant's behavior has been significantly erratic. This is, we do believe, in part due to his drug use, as the court heard about when we were first here in court, his use of methamphetamines. So we do believe that this minor child's safety is at risk, that the supervision component needs to be modified, and we're asking the court to issue an order in that regard.
Okay, thank you. Mr. Smith, what's your response?
When we had our thing on the 28th of October, it entered into a judgment that parenting time be supervised by my mother. When I described that to my mother, she had said that she was never aware that that was going to be followed through with. She had been notified that that may be a thing for the future. And then she was describing to me that she was a little bit upset that she didn't get any reassurance that that was going to be carried out. I was the one that gave her the information after the court date on the 28th. In regards to the drug use, everybody at the plaintiff's current address knows that that's not true. So does my mother. And it's already been declared that at 42 years of age and not once prior have I needed to have supervision to see my children. It's been awarded to the plaintiff in this matter. The only other thing that I can say is the fact that in regards to what my mother claims with her affidavit, I did tell her that it was a foolish idea for me to be supervised by her. And I did tell her 2 times in a text message, which I have here, that it was a foolish idea for me to have her supervised before there was a judgment. And if I got a hold of my son, I had no intention of returning him, because that's the exact same way that he was taken from me. In this case, now they're pushing for psychological evaluation. I have those from the plaintiff's counselor that she regularly sees. several packets of paper. I've got journal entries over here that declare that nothing for her to fear would come from me. And beyond that, we have consent for a 24-hour break period the day that she left, August 14th, when the consent was not, when it was deviated from that consent, we should have had something that consent is consent, and consent is the law.
Okay. Anything else, sir?
I would like to say that according to the Bible, I only need to declare 2 times that for anyone that tries to create division amongst us. So this is the 2nd time. And I pray for mercy on everybody's soul.
Okay.
Because I'm done.
Thank you, sir. Well, in this case, the defendant has acknowledged that he did say it was his intent to not return the child. He just stated that. And as a result,
prior to his judgment, prior to the judgment.
Okay, that's a concern in this matter. There is an order from the hearing on from October 28th, 2024, for ordering supervised parenting time. And the court is not going to change that order. And it does appear that the defendant's mother is not able to, or unwilling to, or just not able to at this particular point. So the court will grant the request to have the parenting time supervised by Family Children Services. And I say initially, at this time, the court will do so for approximately 3 months. And at that time, the defendant can petition to have that modified, provided everything is going well with the parenting time. And then at that time, we'd have to potentially look at a supervisor. But if we get a report from Family Children Services, then that may change as well. So that's all I'm going to order at this time. Ms. Podolsky, you can prepare that order and submit under 7-day notice of entry.
Thank you.
Thank you. You're free to go. Have a good day.
Calling case 2021-776 DM Chelsea Joswiak versus Ryan Joswiak. Today is Monday, December 2nd, 2024 at 10:31 a.m.
Court will note the appearance of Ms. Henderson on behalf of the defendant. This matter is before the court on the plaintiff's motion to terminate counseling with Ms. Katz. Go ahead, Ms. Joswiak.
On or around September 6th, I received a letter from Ms. Katz stating that she would be retiring November 30th and that the practice would be closed. She even goes on to state that she can help with referrals and your records. So I took that as we would no longer be using her services. And then I was required to have 2 Zoom meetings with Ms. Katz and the defendant. And the second meeting, it ended with Ms. Katz saying that she is backing out of this, that we do not want to work together. She said, you two do not want to try. You don't care enough about your child's best interest. She feels sorry for our children and there's nothing else she can do. She quits. I then asked who she was speaking to, and she said both of us. By the end of the Zoom, it then led to, Ryan, I'll see you on Friday. We have an appointment. So insert the bias treatment that was received several times over this. Also in the letter, I didn't get any information that Ms. Katz would be servicing people separately after retiring, although the defendant's motion claims that the defendant and the children can continue going if they are willing. All parties know the children are not willing. Last I was told, they didn't attend 2 of the sessions. They refused to go into the room. Since then, the defendant and I have both put my son's personal counseling on pause as he does not want to speak. So that would make him unwilling. And my daughter doesn't want to go either. The transition period is now over. The kids are with the defendant for 5 days and with myself for 3 until the 92 days are made up. We no longer require Maridessa CAD's services in this situation. It is only added to toxic behavior and unwanted things between the defendant and myself. Also, I believe that this is retaliation on her side, as Dr. Hogan is under investigation regarding this case, and so is Maridessa, for discrimination, unethical practicing, possible dual relationship, and bias counseling. So I would like to terminate this service from her. If you deem that it's necessary, we continue counseling, such as family counseling. I would suggest Margaret Hunter. She's had success with many people in this same situation. Thank you.
Okay, thank you. Ms. Henderson?
Thank you, Your Honor. As we stated in our written response, Ms. Katz is willing to continue working on a part-time basis, even though she is retiring from full-time practice, specifically with defendant and the minor children. It is correct that due to the breakdown of the relationship between Ms. Jazwiak and Ms. Katz is no longer willing to work with Ms. Jazwiak, and that's largely due to her belligerent behavior during the sessions. There is a motion that was scheduled for next week in front of Your Honor due to the concerns that were expressed by Ms. Katz regarding Ms. Jazwiak's behavior. So at this point, Your Honor, we would not object to Ms. Katz not working with Ms. Jazwiak anymore. But we're asking that my client be allowed to continue working with Ms. Katz on a part-time basis, as well as minor children if they're willing.
Okay. Well, in this case, court would note that I've had obviously Ms. Katz as well as Ms. Hunter in my court numerous times before, and I've always found both of them to be very professional and objective in the case. Not to say that there hasn't been disputes, as there obviously was in this particular matter when they find that they can't work with a particular party. What happens is court would order that, again, the counseling with the children and the defendant would continue with Ms. Katz if she's willing to do that, and that as it relates to any co-parenting counseling between the parties, that Ms. Katz would make a recommendation as to who could handle that counseling, because clearly it appears that there needs to be some counseling between the parties in this particular matter. Ms. Henderson, the plaintiff has recommended Ms. Hunter for that. Do you have any problem with Ms. Hunter doing the co-parenting counseling?
I do not, Your Honor. I've had Ms. Hunter on several cases. I have no issue with her stepping in.
Okay, why don't we do that? Put that in an order, and we'll have Ms. Hunter, who will provide the co-parenting counseling in this matter, but the parties can, the defendant and the children can continue with Ms. Katz if he desires, or he can move that to Ms. Hunter as well if he wants to. So,
Your Honor, did you still want Ms. Katz to render recommendations?
No, not if you've agreed that Ms. Hunter would do it. So.
No, I have no issues with Ms. Hunter. I've had her on several cases.
Okay. Why don't we do that? I guess I'll ask Ms. Henderson. I know it's not your motion, but I'll ask that you would prepare the order and submit under 7 days. So that gets completed.
Yes, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you.
Calling case 2024-3089 DM, Kathleen House versus Jonathan House. Today is Monday, December 2nd, 2024 at 9:10 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, Mr. Bartel on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, payment of bills, and exclusive use. Ms. Podolsky.
Thank you, Your Honor. As we've stated in our motion, the defendant vacated the marital home back on April 27th of 2024. The parties have one minor child together who's 10 years old. And since leaving the home on that date, the defendant practiced very sporadic overnights and parenting time. From April 27th through November 2nd, he had 10 overnights with the minor child. This was not because my client was keeping the minor child from him. He simply was not asking for the minor child. Then he was served with the instant divorce matter on November 6, 2024, and then had 9 overnights after that because he saw the request for sole physical custody of the minor child made by my client. At this time, Your Honor, we're asking the court to issue a temporary order granting my client the sole physical and legal custody of the minor child with parenting time to be determined by the court. We believe a reasonable schedule is appropriate. This is in line with what the parties have been practicing since the defendant vacated the marital home back in April. Also, since that time, he has been contributing to the marital bills. He's been depositing paychecks and funds into the joint account, allowing my client to take care of house payments, utility payments, insurance payments, and the like, and to provide care for the minor child. We're asking the court to order that the parties continue with that status quo so she can continue to make those payments as he did vacate that marital home. He has since found a rental. In fact, it is right next door to where she is living. But we do believe it is important that he continue to maintain the status quo with her financially, as this is what the parties have been doing since separating 6 months ago. We have outlined in our motion where the parties are employed, what their income is. We believe child support should be set pursuant to the Michigan Child Support Formula, and we're asking the court to issue this order today.
Okay, thank you. Mr. Bartel, I read your answer and you said that he was exercising 50% of the time. Was that after the November 6th date when he was served or what?
It was around that time, Your Honor, but I would like to back up. There are text messages, and I think it's a bit disingenuous for a plaintiff to suggest that my client had not actually asked for more parenting time. For example, August 24th, there was text messages back and forth in which the plaintiff indicated that she would not do anything except for the weekends. My client says that's not acceptable, and I want more overnights. So my client originally was not, as we put it forth in our answer, he was trying to, I guess, not rock the boat, so to speak. Your Honor, there is actually a very close, tight-knit bond between the minor child and my client. He, every single day, Your Honor, picks up the minor child from school, and he consistently has him for at least several hours, if not until his bedtime. And, Your Honor, that has been the case since the child has been going to school. The child is almost 11 years old here in about a week. The child had a breakdown within the last couple of weeks because he's fearful that he's not going to have significant contacts with my client. My client did not want the minor child being put in the middle of this. All he said was, I'm not going anywhere. I'll be here. And he didn't want to get into the fight in court, at least the portrayal by plaintiff that he does not have significant ties with the minor child. Your Honor, my client now does have roughly about 50-50. We don't deny for a number of months there, he did not have as many overnights, and it's not because of his own choosing. It is because of plaintiff, and he didn't want to rock the boat. But let's not forget, for the first 10 and a half years plus of the minor child's life, the significant contacts and everything that my client did with and for the defendant. He is significantly involved in the minor child's school. He goes to every school event. He helps them with his homework. He just recently, Your Honor, they went hunting again, and the minor child got his first buck. That is how close of a bond they have. I would suggest they have actually a closer bond than plaintiff does with the minor child. But my client knows and recognizes, despite that, it is in the child's best interest for them to continue on with what has historically been a 50-50, at least a 50-50 arrangement will be in the best interest of the minor child going forward. With regards to the expenses, your client, now that we're in this action, I think things have changed. There is going to be child support that is going to be calculated. That is a change from what is before. plaintiff does work. She wants to be in the house. She wants the exclusive use of the house. My client does not disagree with that and is fine with that. But she should pay for everything related to the house. My client has his own place that he has to pay for, and they can be responsible for their own respective bills, such as cell phones, etc., which my client had been paying for. So we would ask for there to be joint legal and physical custody in this matter, and for there to be alternating weeks for parenting time. I would also like to note my client's parents have heavily been involved in this matter with the minor child, and I note that because there are many times, even of recent, that plaintiff is asking my client's parents to help out if they both are at work. The plaintiff went back to work approximately 4, 5, 6 weeks after she gave birth to the minor child. My client's parents watched the minor child every single day until the child went to school. Okay. And historically, like I said, since plaintiff works beyond when the pickup at school is, my client has always picked up the child, always. And we wish that for the roughly 50-50 to continue forward. That's in the best interest of the minor child. If anything, this minor child is going to be devastated if plaintiff gets her way. And there is no doubt that the minor child wants to have that significant time with my client, and that should continue forward, notwithstanding the several months that plaintiff wanted control in this matter. And it became very clear what she was doing retrospectively.
Okay, thank you. Ms. Podolsky, any response?
Thank you, Your Honor. If the defendant were concerned about the minor child's devastation, he would not have left 6 months ago and then stopped seeing him on a regular basis. Instead, as counsel stated, he didn't want to rock the boat and he didn't do anything for 6 months. Your Honor, the reason why my client was concerned about weekends and weekdays and continues to be concerned about weekdays is because the defendant works at 5:30 in the morning. On the nights when he has kept the minor child during the week, during these last 3 weeks since being served, the minor child is coming back to her, going to school cranky, moody, snarky, disrespectful to her. And that's a significant concern. That's just going to lead us down a tricky path with school. It can lead towards poor performance in school and this mood continuing in school. So we don't believe that overnights during the week would be appropriate because of that work schedule. And yes, my client does work outside of the home and has gone back to work since the minor child 10 and a half years ago. And we're not going to shame her for working outside of the home. The parties did use the defendant's parents as childcare, and she's continued to remain in contact with his parents. She's not divorcing them. These parties are getting divorced. She's maintained a civil relationship with them so they can continue to have a relationship with their grandson. So, Your Honor, we do believe our request is appropriate and is in line with what these parties have been practicing for the last 6 months.
Your Honor, can I just make note?
Hold on a
I'm
second.
sorry. Let's hear
Ms.
the motion.
Podolsky, do you acknowledge that the defendant has been picking up the child from school and having him each day?
He has, it's not every day. He has picked up
I
the minor
understand.
child. Yes, but yes,
Okay.
he has picked up the minor child after school.
Okay. Mr. Bartel, what else did you want to add?
I just want to briefly respond to a couple things. Number one, with regards to the teacher thing, my client last week actually, we knew this was going to be brought up. He spoke directly with the teacher, and the teacher said there has been no moodiness or change with regards to the minor child. I would suggest 50-50, and the court wants an evidentiary hearing that would be fine to show this lie that now is being peddled by the plaintiff. The child has been fine, but with regards to that, Your Honor, I would also make 2 notations. My client's parents, if need be, are willing to watch the child for that half hour or so while he goes to work. But the other thing I would note, Your Honor, is, this one other case I had with you about 6 years ago, you're not going to remember it, but I had a case from St. John's where the kids were coming down from St. John's to Penfield, hour 15 minutes each way, and this court didn't have a concern around the same age that they would have to be getting up about 5:30 in the morning. I would just make note of that. Finally, Your Honor, my client has been picking up the child every single day after school. Who else is? Plaintiff is working. That's just not true, Your Honor.
Okay,
And my client has consistently every single day seen the child since he's left the marital home.
okay.
And
I
that
don't
should
need it.
continue.
I don't need anything else,
Yeah.
Mr. Bartell. Obviously, your memory is much better than mine from a case that's long ago, so I have not much
Stuck out.
recollection. In this case, however, the court does note, as acknowledged by the plaintiff, that the defendant has been picking up the child after school, having him in the evening. So it does appear that both of the parties are heavily involved with the child, notwithstanding a period of months where, after the separation, where he maybe didn't have the child on an overnight basis. The court does believe that, based upon what's been presented at this point, that there is an established custodial environment with both parties. So what the court is going to do is grant to the parties joint legal and joint physical custody. The parenting time shall be in alternating weeks, commencing at 6:00 p.m. on Friday and then proceeding to the next Friday, with each of the parties having a midweek on the week that the other party has the child. The court would set support pursuant to the support guidelines, order that the parties would exchange all income information within 7 days of today's date, so that we can have a calculation of the support. The court would grant to the plaintiff exclusive use of the home and make her responsible for all the expenses, mortgage, taxes, insurance on the home while she's in possession of that. That will be the order. Ms. Podolsky, you can prepare that and submit it under a 7-day notice.
Thank you.
Okay, thank you all. You're free to go. Have a good day.
All right, thank you. You too.
Case 2021 981 DM Zachary French versus Elizabeth French. Today is Monday, December 2nd, 2024 at 9:03 a.m.
Good morning to everyone. The court would note the appearance of Mr. Bailey on behalf of the plaintiff, the defendant appearing in pro per. This matter is before the court on the plaintiff's motion to enforce court order, hold defendant in contempt, and for attorney fees. Mr. Bailey.
Thank you, Your Honor. I believe the motion speaks for itself. The defendant was granted sole legal custody by this court just a few months ago, and plaintiff and defendant, Ms. French, has been filling Flonase prescription at her place of employment. She's a licensed pharmacy technician. She's doing so without the permission of the plaintiff and doing so without the permission of the medical professional who originally prescribed the Flonase. Additionally, Your Honor, since filing this motion, there's been some recent events where Child Protective Services is now investigating Ms. French regarding the cleanliness of her home. The Ingham County investigator, who was a liaison because this occurred up north, Brett Gates, went to my client's house last week, informed him of this investigation, asked him to look into an emergency motion. And additionally, Mr. French then informed CPS of this motion and the medical and the prescription that's being filled. So now CPS is investigating Ms. French for the cleanliness of her home, as well as the medical treatment of the minor child, Amelia. So our original prayer for relief, Your Honor, was to have the parenting time schedule that's set to be implemented next fall, which is an every other weekend for Ms. French. We wanted that to be implemented today just because of her lack of discretion with this minor child, the medical care without a medical professional's advice or consent, as well as without Mr. French's consent. But now with CPS investigating this matter even further, we believe a suspension of parenting time may be adequate for a couple of weeks until we can get this investigation resolved. As a result of filing this motion, my client incurred $1,360 in attorney fees, and we would request that Ms. French pay that to the plaintiff for having to file this motion to enforce court order. Thank you.
Thank you. Ms. French, how are you able to, and why do you believe that you're able to acquire medical, attention or medicine for the child when you do not have legal custody?
I did not know I was unable to fill my daughter's prescribed prescription. That was not explained to me. These prescriptions are fully legal and were sent in by the provider. And the one that Mr. French seems to think is a false script was sent in twice on 6/24 at 1:03 p.m. and 1:06 p.m. I was not at work at this time. Other people have typed these prescriptions and were filled by other individuals. I picked it up and I provided the Flonase for Mr. French's household and my own, because Mr. French refuses to fill the prescription for our daughter.
Okay. Well, in this particular matter, when you do not have legal custody, you cannot acquire medical treatment for the child, except instances where it would be an emergency situation, such as an accident or something of that nature that occurred when the child was in your care. You cannot acquire routine medical attention or anything of that nature.
So I am unable to pick up her prescriptions.
You're unable to do anything other than emergency medical treatment.
Okay, I do apologize. I was unaware of that.
Okay, because the plaintiff has the sole ability to do that at this point. I'm not going to, in fact, suspend the parenting time at this point. Obviously, we don't know what's going to happen with the CPS investigation. It's not before the court. It's not in a motion, so I don't have it before me in this particular matter. Court at this point is not going to hold the defendant in contempt. She's given an explanation. I don't know the merits of it, other than it seems like that could be reasonable. So I'm not going to find her in contempt without having a hearing or having more information than I have. But a court does find that it's appropriate to assess the attorney fees for these proceedings. As again, she said she wasn't aware of it, but that's her obligation to be informed of what's in the judgment as well. So the court will order attorney fees in the amount of $1,360, which shall be paid within 60 days of today's date. Mr. Bailey, you can prepare an order and submit it under 7 days.
Thank you, Your Honor. And if we do find out more information from Child Protective Services, would you like us to schedule just a regular motion hearing around this time?
Yes, what you're going to have to do is you'll have to file a motion, and then Ms. French will have an opportunity to respond.
Okay, thank you.
Okay,
Thank
can I
you.
please state that CPS has been in my home and these false allegations have been shown false? There's been no further communication.
Ma'am, that's not before me today, so I'm not considering any of that.
Okay, I just wanted it on the record that that has been proven false.
Okay, and I want it on the record that that's not before me today, so I'm not dealing with that. So you're free to go. Have a good day.
Thank you.
Thank you.